アメリカでスラップと呼ばれる口封じ裁判。まるでビンタを浴びせるようなものという意味が案に込められています。宇賀谷さんが訪ねたのはカリフォルニア州北部の田舎町。スラップの被害に遭ったごく普通の市民、一組の夫婦でした。リッチ・マイヤースさんは30年間このドライクリークという土地に住んできました。ところが3年前、飲み水用の水源が濁るなどの環境問題に直面しました。
Creek would be, couldn't see to the bottom of the creek like you can now.
Wow, it's that bad.
Really bad. Color would be gray.
水質汚染の原因は金の採掘会社による露天掘り工事でした。
This side right down here is where the plant was. They brought the cut in the side hill is where they were mining.
Okay.
マイヤースさんは近隣住民と連携し、苦情の申し立てや環境調査実施などを求めました。すると採掘会社は突如巨額の民事裁判に訴えてきたのです。マイヤースさんたちがホームページに掲載した採掘現場の写真。採掘会社はこの写真が掲載されたことで企業秘密が漏れ損害が生じたと主張。100万ドル、日本円で1億円近い損害賠償を求めてきたのです。
How were you feeling when you first learned that you got SLAPP? I mean, you were filed a lawsuit against you.
Intimidated.
Intimidated?
And
very scared.
Scared, yeah.
Scared. Scared for what? What possibility?
Well, the SLAPP was for $1 million, and there is, even though we felt we were in the right, and you never, we haven't had much dealings with the court system, but know that nothing is sure when you end up in court. And I think we felt the strength of numbers, and everybody had the same opinion that there was no basis in fact in their suit, so we didn't feel that there was any chance of them winning. But
it was still scary.
It was still very scary because you don't know.
We have never been involved in anything like this before. No anything to do with the courts or police or anything. So
that's quite natural.
突然の巨額訴訟に狼狽するマイヤースさんたち。ところが2週間後、ある弁護士を紹介されたことで状況は一変します。スラップ対策を専門に扱うマーク・ゴールドウィッツ弁護士です。
Had you been knowledge about a word SLAPP before you got sued? No. Okay. Existence of the anti-SLAPP law in California state law. When did you know that?
When we contacted Mr. Goldowitz, he informed us. Luckily, we were able to contact an attorney who took it on quite soon.
Okay.
So we were not in the dark for very long, but yeah, we didn't know what to expect. We didn't know exactly how it was going to happen.
アメリカでは28の州と地域にスラップを規制する法律があり、カリフォルニア州もその一つです。ゴールドウィッツ弁護士はカリフォルニア州の法律に基づき、この裁判はスラップだと動議を出しました。半年後、裁判所はこの申し立てを認め、採掘会社の訴えを棄却、つまり門前払いしたのです。住民側の全面的な勝利でした。
It was great relief for the SLAPP victims.
Oh yes.
Yeah, it's really great.
We had a party.
And we had a little celebration party here and had champagne and hors d'oeuvres for, there were about 35 people here.
Did you have to pay a certain amount of money to hire Mr. Goldwitz in advance as an initial fee?
No,
No.
we didn't. The only we had to pay filing fees, which amounted to about $300.
$300?
Yeah.
実はカリフォルニア州の法律ではスラップが認められると裁判を起こした側が全ての弁護士費用を支払う義務を負います。住民側弁護士費用$24,000は全て採掘会社の負担となりました。
私、その弁護士費用だけで多分200万円ぐらい使ってると思うんですけれども、もっと使ってるかな、300万ぐらい使ってるかもしれない。それだって庶民にはものすごい痛い出費ですよね。それを提訴させた側に負わせる法律があるっていうのは、すごいことですよね。弱いものを守るっていうことに貫徹してる法律があるっていうのはある種やっぱりこう唖然としてしまいますよね。
宇賀谷さんはマイヤースさんらの弁護士でもあったスラップ対策専門家を訪ねました。スラップを規制する意義について意見を聞きたかったのです。
Why is SLAPP dangerous?
Or why should it be stopped?
SLAPP is dangerous because it punishes people for exercising their fundamental right to be able to speak to the government or to be able to participate in civil society. And if SLAPPs are allowed to continue, they will have the effect of silencing.
アメリカのスラップ規制は市民の当然の権利を守るという発想から始まっていました。先ほどのマイヤースさんの例で言えば、住民が苦情を申し立てるのは当然の権利で、採掘会社がそれを訴えてはならないという考えです。
Some Japanese colleagues, journalists, call SLAPP as a lawsuit terrorism. Yeah, legal terrorism, litigation terrorism. Yeah,
That's what you say?
Litigation terrorism.
宇賀谷さんはもう一人のキーパーソンを訪ねました。カリフォルニア州のスラップ規制法を起草したジーン・ウォン弁護士です。ぜひ聞いてみたい質問がありました。
This is a question from my friend lawyers back in Japan. Okay, how do you, let's say, reconcile on what should I say, make a compromise between right to file a lawsuit and free speech? Because those corporate lawyers who file the SLAPP lawsuit in Japan always argue that okay, everybody has a right to sue, file a lawsuit. So what's wrong about it?
Everybody has a right to sue, but you don't have the right to abuse the process. That's the difference. If you file a lawsuit to protect your rights, that is one thing. If you file a lawsuit to abuse the process, that is another thing. And that's what this statute very clearly says. We recognized back then that the right to sue could be abused.
誰にでも裁判を起こす権利はありますと。それは間違いありませんと。だけれど、誰にも裁判制度を悪用する権利はないっていうふうに彼ははっきり言ってるわけですね。自分の思ってることを言ったがゆえに裁判によって提訴されて、それによって罰を加えられるんだったら、それこそがその民主主義の敗北だっていうふうに言い切っちゃうわけですよね。
もう一人会っておきたい人物がいました。スラップという言葉の発案者、フロリダ中央大学のペネロピ・キャナン教授です。キャナン教授はスラップの実例を多数調べ上げ、いち早くこの問題に警鐘を鳴らしました。
You know how it took you 33 months?
How?
I mean, you remember that it took you 33 months and the average is 48 months. And I've seen some that lasted for 10 years. I have interviewed children who told me that they started high school and every night in their entire high school of 4 years, dinner time at the family table was only talking about the SLAPP. Their whole high school. I mean, you know, it just can rob a family. It's like an elephant moves in with the family. You remember, wasn't it horrible?
Yeah.
And so the SLAPP target should say, stop, this is privileged speech. My speech was privileged. I get to talk to the government. You can't file a lawsuit against me for doing that.
なぜ言論の自由を行使しただけで、苦しめられなければいけないのかっていう現象が出てきた時に、彼らはこれは法律は間違ってるんだっていうふうに気がついたわけですよね。だから俺たちの手で法律を変えちゃおうぜと。っていうふうに始まって、市民や NPO が議会に働きかけて、最後は議会がそういう法律を作る。